Good morning, Jon Sharp.
Good morning, Julie. How are you?
I'm good, thank you. I believe, are going to be doing an update on the COVID-19 versus the insurers response, your regular monthly update.
Yes, this is a little update for everyone.
Now the dust has settled, who did win the FCA versus the insurers test case?
Well, who won? No, now the dust has settled. The generally held view is that the FCA won. And having now read the judgment, 165 pages long, there's no doubt that they did in the majority of the cases. So as you remember, there were 27 policy wordings being reviewed. In the majority of the cases, there was found to be cover, either because of a notifiable disease extension or because the collective acts of the government in effectively closing offices, etc., they found in some cases as well that that is also an insured event. It wasn't true in relation to all insurers, it has to be said. It would be wrong of me to say that it was a complete slam dunk to the FCA. It wasn't. There was one insurer called Ecclesiastical. They had 3 policy wordings which were being looked at by the court, and the court ruled that in relation to those policy wordings of Ecclesiastical, no cover existed under either head, so either notifiable disease or act of government. So they were very happy people and walked away. Others, not so happy. Our good friends Hiscox, who are just across the road from our offices, they didn't fare quite so well. Hiscox, and I think everyone knows, Hiscox offer quite wide coverage and have always said that they pay 90% of claims, or I think actually 99% of claims. But they didn't in relation to this, to COVID-19, and the court found that they were wrong to have not provided cover and that there was cover under all of the Hiscox policies. So Hiscox are not very happy people at all. Other insurers, I think Zurich had 3 that were being looked at, only 1 was found to have cover. So it wasn't, as I said, a complete slam dunk to the FCA, but I think it's probably fair to say that, 75%, it was a 75% win for them. One of the best things about the judgment, curiously, is actually the start. There is a very detailed blow-by-blow account, factually, of what happened from the moment, effectively, that lockdown started mid-March, and the various acts of government, etc., are all very clearly set out. It's absolutely excellent. So if anyone's looking for a chronology of what actually did happen, that's a good place to go. I don't think it's been argued very much about, so there we are. I think 75% to the FCA, 25% to insurers.
Okay, so what is happening to the case now?
Well, as anticipated, and indeed as anticipated in what was called the framework agreement, which was entered into between the FCA and the insurers, there was provision for parties to appeal. And guess what? They've appealed. I don't think Ecclesiastical have appealed, but certainly Hiscox have appealed, and some of the other insurers as well. And equally, the FCA have also appealed. They're saying, well, actually, no, we don't think the judge was right to say that, these policies didn't contain cover. So there is quite a few appeals going on. Now, these are going to be what's called expedited, and they're going to leapfrog the Court of Appeal, primarily because one of the judges who decided the case stepped down from the Court of Appeal to, if you like, the Commercial Court of First Instance. And so the leapfrog in the Court of Appeal is going to go straight to the House of Lords. Now, I'm not quite sure yet of the timetable. I don't think the FCA are as well, because they've been very good at reporting things. But maybe on their website, to be fair. But I'm not expecting to get those appeals certainly heard much before, I would have thought, beginning of November. And a judgment is likely probably towards the end of November. So again, it's going to be the end of November before we get absolute certainty, because once the Supreme Court, sorry, effectively the House of Lords, has ruled on it, then that'll be that. Again, I suspect that for a fee, you will be able to watch the appeal. You could certainly, with the proceedings at first instance, I can't see any difference this time. There is a fee to pay, but I don't think it's a huge amount. So if you want to follow it live or look at your particular insurer, there'll be a timetable set out by the judges. You should be able to tune in. So it's all been, as I've said, and I do congratulate the FCA for this, it has been the most transparent piece of litigation, certainly in my 32 career, I've ever come across. You know, the ability to watch it live, reports, the pleadings, they're all on the FCA's website, and they have to be applauded for that. And it's also true, the FCA have not, you know, this has not been, as I've said before, a cozy arrangement between the FCA and insurers. The FCA have really, you know, gone for them, you know, really has pushed the point as much as they can. So no one can say this has not been a very fair, transparent process.
Okay, so gold star for the FCA then.
Yes, actually, gold star for the FCA. Much maligned over the years, but this time you can't argue with what they've done. They were quite correct. And I said, actually, to be fair to me, I'm not blowing my own trumpet here, I did say back in March, April, that I'd be surprised if the FCA did not take some form of action. And sure enough, they did. So, yeah, that's all good.
Okay, put away your crystal ball, Mr. Sharp. So what advice do you have for people moving forward?
Right, well, now is the time, if you think you have got, is to dig out your policy wording first of all. And if you have one of the more expensive business interruption policies, you need to look carefully at your clauses regarding notifiable disease and also regarding acts of government. Now, if you've got that in there, then you may have cover. The problem, Julie, is this, that there are still 78 wordings out there, only 27 have been looked at, and the difference between the 27 and the 78 in terms of minutiae of wording, etc., there will still be different types of wording and open to interpretation. And the FCA test case was not intended to be binding on those. But what the test case has done is now we have a template, if you like, to measure these wordings against. Whereas before, nobody really knew, apart from that one case, the New Orleans hotel case, which I won't bore everyone with again. I've bored everyone with it at least twice now. There wasn't really very much else. Now there is a template. And I have to stress that if it was me as an owner of a business, and I had a policy wording that contained one or two of these clauses, I would go and instruct a solicitor. And I would say, look, this is my policy wording. This is the judgment. Have I got cover? Now, because it is complicated, there's no two ways about it. The judgment had to be complicated because they had such a lot to cover. But most barristers, especially insurance barristers, have brains the size of planets. And they will have looked at this and have read the judgment. And it will not take them long to compare your wording against what the judgment actually said to see whether you've got some cover. And that should not be an expensive process. All the solicitor's got to do is prepare some instructions to counsel, say, we act for so-and-so, this is his policy wording, we're aware of the judgment, what do you think, has he got cover? And I would have thought you'd be able to get a counsel's opinion for maybe £1,000, and that will then tell you whether or not you've got a good opportunity of recovery. If you have, and there's no reason why you shouldn't be starting this now, you know roughly what losses your business incurred. Speak to your broker about what your particular policy covers you for. It may be loss of turnover, it may be profit, it may only be losses that directly arise from. And so the classic example of that would be having to provide additional computer equipment to everyone who had to go and work from home. Yeah, so some policies will be very wide and you'll do, I suspect some people will do very well. Others will be much more narrowly drafted in terms of how much you can recover. But it is not, if you have lost a lot of money, which many, many businesses have, it has to be worth, in my view now, instructing a solicitor, instruct a barrister, and get an opinion on your wording. It has to be the right course of action.
Mm.
So I would strongly recommend that if you have that type of coverage, then you should be having a seriously considering getting the view of a solicitor and barrister as to whether or not cover exists. Is that okay, Julie? That's just a short update. That's roughly where we are at the moment. As I said, the appeal won't be heard and be sorted out, I don't think, until the end of November. But then we will have certainty, and certainly that's the time then to get your instructions to solicitors. But there's nothing to stop you now starting to get your figures ready. Look, your broker will be able to tell you what it is that you are covered for, and there should be no harm in getting the paperwork together with evidence, so that if then when you get your counsel opinion, yeah, you've got coverage, you can fire it straight off.
Perfect. Okay, that's great. And I'm assuming we'll do another roundup as soon as they release any more details.
Yes, I probably won't do one now until the House of Lords Supreme Court's judgment's out. But that's where we are at the moment, and that would be my advice to most people.
Okay, that's great. Thanks very much as always, John. That's always useful to know. So thank you very much for your time this morning. And
thank you, Julie. Love to see you as ever.
Take care.
Bye-bye.